For attending our presentation tonight. My name is Haig Himidian, Armenian Bar Association member since 2015. I'm an associate at Taxman, Pollock, Bekkerman, or TPMB. The firm specializes in plaintiff's injury law, including medical malpractice, nursing home negligence, products liability, construction liability, catastrophic motor vehicle collisions, amongst other bodily injury matters. It is my honor to present tonight's speaker, Kathy Ossian. Kathy is the founder and CEO of Ossian Law, which provides legal expertise in all areas involving information technology and the internet. Kathy is a frequent speaker and author on IT law trends and topics, and she has won numerous awards for her knowledge and work in the area of IT law. I'm very much looking forward to hearing Kathy's presentation tonight, so without further ado, ladies and gentlemen, Kathy Ossian.
Thank you, Mike. Thank you. So, our general topic is avoiding legal issues online. And our more specific topics will be who's borrowing your brand online, and that's just kind of a cute way of saying we're going to talk about how you should protect your brand online. Ownership and control of digital assets. In most of it, we're going to talk about focus on social media accounts. And then key clauses in technology agreements. And you know, we have a good-sized group, but if you have a question at any point, feel free to ask. I'm happy to address it, because sometimes if you don't get your question answered right away, you lose it. So feel free. So let's talk a little bit about brand. A brand is a source identifier. That's really the kind of how to put it in a nutshell. If we're talking about products, it's a trademark. If we're talking about services, it's a service mark. I actually have a service mark for my firm. You might have seen it on some of the promotional materials that I handed out. Keeping IT legal. And I actually have a registered trademark for that, which is a service mark because I provide services, not products. So that if someone sees that mark, they could identify that with that I am the source of those legal services. Trademarks become stronger through use. That's really how they build their strength. And the best marks are really fanciful rather than descriptive. Well, what do I mean by that? Well, Apple is a good mark for a computer because Apple doesn't describe a computer or anything about computers. On the other hand, something like Visiting Nurses Association is not really it's not going to be a strong trademark because it's describing exactly what the services are. So if you're thinking about coming up with a brand, those are things to keep in mind. You can also federally register a trademark, and you do that through the U.S. Patent and Trademark Office, the uspto.gov. I've given you the link there. That's really the best way to protect a trademark, although there are also common law rights that vary by geographic location, state by state. So why is it important to protect your brand? Well, you want to prevent someone from using your brand without permission, which is also called trademark infringement. And there is a concept called acquiescence. So what I've given you here are some generic terms that everybody's familiar with. Well, these used to be trademarks. So Bayer used to have a trademark for aspirin. But what happened? Well, what happened was other companies started referring to their pain reliever product as aspirin. And Bayer didn't object to it, and therefore they were acquiescing in others using their mark, and those marks became generic. So that's true for, these are just a few, there are a lot of others, but that's one of the consequences of not protecting your brand is it can become generic. So some of you might be thinking, well, wait, what about Google? Right? Because everybody will say, Google it. I guess they're not worried about it. I don't know. If I were counseling them, maybe I'd tell them to do some things, take some steps to try to prevent that. Because there's a fine line. On the one hand, you want everyone to know your brand and recognize your brand, but you don't want your brand being used in a generic way. How many of you are familiar with social media vanity URLs? Anybody? Show of hands? A couple people. Okay. So essentially what a vanity URL is, it's a way to kind of shortcut if someone's doing a browser search and they're looking for your social media page. It's a way for them to get there kind of faster. So if you can see it, it's a little bit small in the slide there, but this is the Twitter page for my firm, and essentially it's someone just puts into the browser, twitter.com/Ossian Law PC, and it takes you right to that particular page. So these are available on Facebook, Twitter, and I think maybe Google+, and maybe some other social media sites do provide for these vanity URLs. So there are ways to check to see if your brand is being used on any number of social media sites. And the way to do that, I'm going to walk you through a couple of examples, but the way to do that is you can just do a browser search for username check. Now several sites will come up. I'm not endorsing any particular site, but I'm going to use, well, you'll see the one that I'm using, and just by way of example, we'll use Pepsi and Nike because these, of course, are very, very well-known, famous brands. So you can see that this particular site is name check with not quite all the letters there. And so what you would do is you would put in your brand, and then it's going to tell you the black ones show these are already taken, the green ones apparently are available, the yellow ones, I'm not sure exactly what that means, somewhere in the middle. So if you actually click through, like on the Facebook one, it does take you to what is Pepsi's Facebook page. Okay. Same thing for Twitter, definitely Pepsi's page. Now I don't know if anybody still even uses MySpace, but in any event, when you go to myspace.com/Pepsi, it is not Pepsi. This clearly is someone else, and for whatever reason, I guess Pepsi isn't concerned about it. But just kind of interesting to show that even large brands have these issues. So let's see Nike now. So kind of a similar result here with a lot of them already taken, a lot of them saying they're available. Click through on YouTube, and this is definitely Nike's page. And again, when you go on Pinterest, it is Nike's page. However, when you get to Flickr, this, even though it says photos/Nike, it takes you to a page that is definitely not Nike. So I'm going to talk about a specific example of social media hijacking, and this was actually a client. I've changed the name, but this is something that took place back probably in 2010. I'm not sure exactly when, but it's been a while. So there was a company, and I'm going to call them Acme Chili, and they were a long-standing kind of family-run company. They really didn't want to be in the forefront of social media by any means. But I got a call one day from the director of marketing. And he said, somebody put up a page and it has our name and it's not us, but it looks like it's our business page. And sure enough, when I went and looked at it, that's exactly what it looked like. It had their name, it had pictures of their products, and it was set up as a business page, not a fan page, not a personal page, but an actual business page. And the photographs of the products were actually taken from the company's website without permission. There were a number of posts talking about the product, but then there was also some misinformation being given. So people would ask a question about a particular product, and the person, whoever was running the page, was not giving necessarily the right or correct answer, and this was of concern to the client. So the client asked me what to do. And my immediate answer was, you can just have the page taken down. There's, you go click the button and ask Facebook to take it down. Well, they did not want to do that. There were already, I think, maybe 300 or so followers of that page, and the client was not comfortable doing that. They felt that they didn't want, from a customer relations perspective, they didn't want to do that. They told me they weren't ready to put their page up yet, which, was like, okay. So what are your other options? Well, you can monitor the page, you can correct things when it makes sense to do so, and as far as the page administrator goes, you can kind of ask them to contact you. So they did, and the first time they did that, they were ignored. The second time, they did hear from the administrator, and it turned out to be a teenage fan of their product who just thought he was setting up a fan page, I guess, if you give him the benefit of the doubt. So at that point, once they discovered who it was, they invited him to their offices and gave him some free products and gave him a tour and asked him to turn the page over, and he said no. So then they called me back, and what do we do now? And I said, well, you want me to, I can send a cease and desist letter. So we did that, got their attention, but at this point, we end up, the father of the fan ends up hiring a lawyer, or maybe it was a friend of the family, I don't know, but we actually had like a sit-down meeting about this. And, I had said to the client, well, you can't really ask him to turn the page over, but there are things we can ask him to do. First of all, it should be an actual fan page. It shouldn't be a business page. He shouldn't be using any photographs or any other content of yours without permission. He should put up a disclaimer to say this is not, he isn't affiliated with the company. All of these various steps. So we actually had a settlement agreement that went through all of this. But now, remember that he's a minor. So he can sign the contract, but then he can avoid it, right? He can just walk away from it. So what are our alternatives there? Well, we could have had a guardianship appointed for him, which was a lot more. We weren't going to go down that road. So what I did is I kind of structured the settlement agreement to be like, okay, well, we've given him actual consideration in the form of products, t-shirts, whatever they gave him already. And my hope was that by doing that, if he ever tried to avoid the contract, he would have to give all this stuff back, which wouldn't happen, so I thought we'd be safe. And that's the road we went down. But ultimately, here's what happened. At that time, and I think it's different now, but at that time, you could not take a business page on Facebook and just change it into a fan page. So he ran into this sort of stumbling block in trying to fulfill the settlement agreement. And then about 2 weeks later, I get another call from the client saying, someone hacked that page. Now I know it wasn't them, because some of you may be thinking that your client did that. No, believe me, they did not. And at that point, the client was perfectly fine hitting the button, having Facebook take the page down, which is where we would have been in the first place. So it was kind of, I just tell that story to kind of illustrate how these things can sometimes play out, and it's often not for reasons that you might think. So here's an example of Dole. So if those of you are familiar with Dole's bags of salad and various things, well, this was a gentleman who was part of a branding agency that decided, to put up on Instagram. He took the Dole bag, but then he made it look like these were, trick-or-treat handouts, right? And he put a caption saying, I would legit call the cops on any house that gave these out. So Dole had to make a decision on, well, what do we do now? We know this guy's, misused our brand, but how are we going to address it? So 4 days later, the post had gotten like 30,000 likes. Dole's official Twitter account posted a cease and desist letter, that's what this is, that the company's general counsel had sent to the individual who put that on Instagram in the first place. And the letter included its own little images with pineapple, broccoli, and carrots. And this is what they said to him in the cease and desist letter. We're thrilled to see you putting so much effort into creating healthier food options. On a more serious note, although we always appreciate being included in any conversation around bringing more fruits and vegetables into everyone's diets, we're certain you didn't get our permission to use our trademarked intellectual property. So it's just one example of how brands are, I think, dealing with things a little differently when it comes to social media and use of brands, because, you know, it's really easy to cut and paste and do all that stuff. It's really easy to infringe someone's trademark. So I'm going to talk about domain names a little bit. Porsche.social. I understand this site is no longer up, but when this was first up, what happened was Porsche itself tried to stop this site from, tried to stop them from using Porsche in the name of it. Even though they had a disclaimer on every page that they weren't affiliated, I think anybody that went there saw that it was clearly intended as a fan page, that it wasn't sponsored or it wasn't being administered by the company itself. And so there was an initial motion that was actually came out in favor of the fan page itself rather than the car company. So that was an instance where, you know, it really wasn't considered to be an infringement. And remember, a lot of what we're talking about with brands is likelihood of confusion. Is someone going to that page really going to think that it's sponsored or put up there by Porsche rather than this other fan group? Now, the second example, though, is a little closer call, because you have the former publisher of the New York Post registering a New York Post Publishing Inc.com, and that was clearly an improper use of the federally registered trademark of New York Post. So, what are some tips for policing your brand online? You know, I walked you through the kind of username searches. You can register or reserve your username or your brand name. It's always good to conduct periodic searches in various ways just to see if your brand is being used, how it's being used. It could just be a browser search. It could be you could go to some your industry-specific sites and forums. And then it's also important to look at Wikipedia and other similar sites. I also had another client who had a problem with something that someone had put up on Wikipedia, and it wasn't an intentional issue at all. It was just that because of the name of their company and the name of a particular product, whoever put this information up on Wikipedia assumed that that product belonged to or was a product of my client when it wasn't. So they authorized me to go in. I just went in and actually corrected that page, and then in doing so, you put your information in there so that if anybody goes back to change it back, you get notified of it. And no one did change it back because I think it really was just a mistake in that instance. So what if you have to reclaim a username or a vanity URL? You know, obviously these are some steps you can take, but I had another instance where there was a vanity URL of a client that it was they had a registered trademark for their name, and the person using it had no clear interest in it. But so I approached it really like it was almost like, you know, sanctioned cyber squatting by Facebook. Because if Facebook is allowing someone that has no interest in that name to use that name, it's almost like it's almost like because they have their own platform, they're allowing cyber squatting, which, there are federal laws to protect against cyber squatting in general, but I argued to them that it was really more specific to their platform, and they did release it within 24 hours of receiving my notice. So as far as domain names go, it is good to proactively register. Part of the challenge, of course, is when it comes to domain names, there are so many new extensions out there that you can't possibly register every single one of them. I mean, .com and .edu and .org, and there's still the main ones are still the primary ones, but you still need to think about which ones does it make sense to do. So if you're doing business in Canada, you probably want to register the .ca for Canada. Don't let your registrations lapse. And typo squatting is an issue, certainly for a lot of banks and financial institutions, because they will use that to then engage in phishing. So another thing that you and your clients can do to prevent, fish. Everybody knows what phishing is, right? Okay. Well, just in case nobody knows, it's when you get an email or a text or whatever, and it looks like it's from your bank or your insurance company or somebody, and they're asking you for account information, passwords, logins, things like that. And a lot of people are still falling victim to this, and the phishers have become more sophisticated, actually. I got an email a couple of days ago, and it looked like it was from another attorney that I know, and it was kind of odd though, because it just had his name and then it had open this file kind of thing, but it looked like it could have been somewhat legitimate. Now my firewall did catch it, so I saw it, when I got my report. I get a daily report from my firewall, but rather than open the attachment, because it didn't say what it was about or anything else, I just sent him a separate email and I said, hey, I forwarded it. I said, did you send me this? And he said no. But so they're becoming more sophisticated, but anytime anything looks even a little bit suspicious, it's always better to check rather than to actually click on something, because that's how a lot of these ransomware attacks are happening. So that's why it's even more important to be aware of the phishing practices and the domain strategies. Okay, anybody have any questions on anything I've covered so far? Because I'm going to move on to the next topic. Yeah.
When you were talking about the Poor Strat Social or the Washington Post domain name issues, because filing suit can get very expensive, would you suggest considering a UDRP action in those situations?
Yeah, and actually one of them may have been a URDP rather than a lawsuit. I think they were actually. Yeah. Okay, so let's talk about ownership and control of digital assets. And of course, as we get more and more, connected, we have so many kinds of digital assets out there. Whether it's your email account, your SharePoint, all of these sorts of cloud-based accounts, could be your blog or web page, bill paying accounts, and of course social media accounts. And I'm just kind of focusing on the business side of it. Of course, we all have our own personal digital assets to deal with as well, but what I'm really going to focus on are the business accounts. So you have an administrator for your account that controls the access and use. And what happens, the big problem is if the administrator leaves, and especially if they leave under not good circumstances, because then you have the potential for just maybe not, it might restrict your ability to access that account or control that account, and even worse, you could have a dispute over the actual ownership of the account. And I'm going to give you several examples of actual lawsuits on this topic. The first one is Phone Dog versus Kravitz. And you had Noah Kravitz, who actually worked for Phone Dog. He was a product reviewer and video blogger. So this Twitter account was a Phone Dog account. It was the employer's account that they provided to him. And you can see what happened when he left. He changed the handle of that account from @PhoneDog_Noah to @Noah Kravitz. And he just basically took the account with him when he left. So this resulted in, they had asked him to stop using it, he wouldn't do that, he did this, and then ultimately there was a lawsuit. They alleged that he had taken their trade secrets and other proprietary and confidential information. They ultimately entered into a confidential settlement, and we don't really know what happened, if any money exchanged hands, but we know that Noah Kravitz kept that account. And a lot of people were looking at this case with great interest because they looked at the number of Twitter followers he had, and they thought, well now we'll find out what the value of a Twitter follower is, because if they have to pay him or he has to pay them so much money, we'll know that. But ultimately, because of the settlement, it never got that far. The next case, the Merrimont versus Susan Friedman Design Group. Merrimont was formerly the director of marketing for this firm, and this is an interior design firm. What happened was she was running this blog, and her Twitter account was actually, I think it had about 1,250 followers, and she said that she had become well known. Actually, this was in Chicago, by the way, in the Chicago interior design community. And when she was on medical leave, the company actually changed the password and didn't give her access to her account and had someone else take it over. So she was very upset about that. But what happened is, in court, they said to prevail, she had to show a loss of sales, profits, or present value, or that the defendants were unjustly enriched. So I don't think she was able to really show damages, even though it's kind of an interesting scenario that kind of brought this about. The next case is Eagle versus Morgan. So Linda Eagle was actually one of the founders of this company and an executive in this company called EdCom. So she had established a LinkedIn account in 2008, and her and one other employee actually maintained the account. Well, in 2011, the company was purchased by another company, and ultimately the employment, of Ms. Eagle and other of the former employees was terminated. So she then tried to access her account and found the password had been changed. She brought a lawsuit against the company for conversion and tortious interference. They filed a counterclaim saying that these were company accounts, and that they were the rightful owner of it. And this case actually went to a trial. They had a trial on this, but neither party was awarded any damages. So I think, to me, this is an example of a lot of wasted time and a lot of wasted money. It seems like they could have worked that out. The next one is Stacy Maddox and Black Entertainment Television, BET. She sued them for conversion after BET actually had persuaded Facebook to migrate the likes associated with a fan page that BET and Maddox had collaborated on to a different page that BET sponsored. And so they were really, what they were fighting over were likes, Facebook likes, which is really kind of interesting. But this went to federal court in in Florida, the Southern District of Florida, said that she could not establish that she owned a property interest in those likes. And I think that is a hard thing to prove, right? Because they're necessarily owned by anybody but, like I can go back and unlike it, right? So I think those are things that are in control of the user, not the person necessarily who has rights in the page. But I still find it a little odd that Facebook would migrate likes from one page to another. And then this last case I think is pretty interesting too, because this was a company, well, there was a cellular company and an employee who left, and the issue here that the court was deciding was, can an employee's LinkedIn contacts be considered trade secrets of the company? Which seems really odd when you phrase it that way, right? Because LinkedIn I don't know how many people have private LinkedIn accounts. I mean, most people would have public accounts, right? And so the the contacts that are accumulated in that account would be available to the public. And if you look at that next to trade secret law, something's a trade secret, that means you're keeping it secret. It's not publicly available out on a website. So that was a little bit odd, but what happened is that there was a preliminary motion, and the court denied the motion, I think, to dismiss the case, allowed it to proceed, said that there was a question of fact as to whether or not the LinkedIn page was public or private. I think they could, it seems like they could have taken judicial notice of that like in 5 minutes in the chambers, right? But in any event, that's what happened in that case. A similar case, they really said that membership in a private LinkedIn group might be a protectable trade secret, but the communications within that group are not. And I think that's right, because maybe it isn't publicly known as to who the members of a social media group are, if it's a private group, but any communications you have within that group are known to the other members of that group. That's not something you're keeping secret. And the other members in that group could transfer that information outside the group as well. Another factor that comes into play when we're talking about ownership and control of digital assets are the terms of service for the particular platform. And of course, they are a contract, they are enforceable. And I don't know how many of you here are old enough to remember shrink wrap agreements when you had to download a disk of the software on it, and you had to agree to terms before you could use that software. That was a shrink wrap agreement. But click wrap, shrink wrap, they're all really in the same category courts consider them to be valid for the most part. There are a few exceptions. But the terms of service do speak to who owns the website, who owns the content. And often there can be terms that say that you as the user have a license to use this, you don't own anything, you don't even own your own content. Now you may be able to take your content down going forward, but whatever content you had out there that was maybe disseminated by other people is still out there, and they're not going to take that content down. So you might still have some control over it, but not all of it necessarily. So a couple of examples here, because there have been instances, even in some of the cases I've already talked about, where those parties try to get the platform to intervene in some way. Say, hey, so-and-so changed my password, I need you to change it back. Well, the bottom line is those platforms really, for the most part, are not going to get involved. And it's kind of understandable that they don't want to be involved. So these are kind of typical responses where they're going to say, look, we can't make changes, to who the administrator is. You've got to work that out. And even Twitter, their terms of service don't directly address it, but when you go to like kind of questions that people have asked about transferring accounts, they basically tell you, you know, you need to handle it on your own. Okay, just can you give me 1 second here, because I don't know what I did to my timer. Oh, my timer's all messed up. Have you been keeping track?
So,
Okay, thank you. All right. Any questions or comments on this topic? All right. So the bottom line is, this is an area where you can be very proactive, and being proactive is going to help a lot to make sure. So a lot of times you may have your web host maybe the one who has all the passwords and is the administrator for all your accounts. That may not be the best idea, depending on who it is. I mean, the other thing is you can have more than one administrator on an account. And so you probably want to have at least 2 people, especially if it's people, you know, employed within your organization. Because if one person leaves, you don't want to be locked out. You don't want to, or you don't want to end up with a dispute. So there are some proactive steps that you can take to prevent being in that situation. Okay, so I'm going to move to the final topic of key clauses in technology agreements. Now, how many of you do contract law? Anybody? Okay, a couple of people do. And I do a lot of contracts, so you know, I guess maybe I feel they're more important than other people do, but they really do play an important role in protecting your proprietary and confidential information or your clients. And just a couple of examples are employee agreements, including, you know, non-disclosure agreements, and then vendor or contractor agreements. And they're equally important for some of the reasons I'm going to talk about. Just there's a lot of terms that really mean the same thing. You know, agreement can come in the form of a click wrap or browse wrap, which I already talked about a little bit. There are still some, you know, traditional documents that are actually signed. Contracts are actually still signed in ink. You can have terms incorporated by reference or by a link, which is a very common thing, particularly in technology agreements. If you go to Microsoft's standard contracts, there's links to everything, you know, and that's true for a lot of big tech companies. Is they just incorporate, so it looks like, oh, it's only a 5-page agreement, but no, by the time you print out all of those linked terms, it's like 50 pages. And it could be some combination of those. And of course, a lot of contracts nowadays are signed with services like DocuSign or things like that, where you're actually just signing it through that service. That's become very popular. And then just some of the terminology, again, that's pretty interchangeable. Whoever's providing the technology service could be the vendor, they could be referred to as a licensor, a supplier, a seller, a service provider, and then the customer can be referred to as a licensee, a buyer, a subscriber, or an end user. And this is not exhaustive, but these are kind of some of the standard terms. And everybody in this room probably knows all this because you've had it. If you don't practice it, you still had it in law school. But you know, the definition of a contract, legally binding agreement between 2 or more people, can be verbal or written, but hopefully it's written. And the elements of offer acceptance, consideration, and mutual assent. Of course, we also have to have legal capacity, like in the example I gave earlier of the minor who had, really doesn't have capacity, or could contract, but then could avoid it, and the lawful purpose. The offer has to be specific and may expire, or it can be revoked until accepted, and the acceptance has to match the offer. So that's just, I tried to sum up kind of the whole, contracts one in one slide. Doesn't cover everything, but. So what are the really important clauses when it comes to technology agreements to protect intellectual property? Well, confidentiality and non-disclosure, I put that one at the top because it is really important. So if you have a client who's going to share any confidential information about a product, a service, something that's proprietary to them, and they're going to talk to a potential reseller or business partner or whoever it might be, even a potential customer, it's really important that they get a non-disclosure agreement prior to making any disclosures. Work for hire. Is everybody familiar with that concept? Okay, so it's really comes in if I have a client who's going to hire a contractor to do to write some code for them, for example, and it's not an employee, it's a contractor. So it becomes very important that they have a written contract that includes the right language, which is to say that anything that contractor does for the client is a work made for hire under the Copyright Act, so that the rights will vest in the client rather than in the contractor, because otherwise the assumption under the Copyright Act is that the contractor would have the rights to it, even though they're being paid to do that work. So it really is an important thing, and it's usually accompanied also by an assignment of right, just in case that work for hire, something doesn't qualify for some reason, then you also simultaneously would say that to the extent that it isn't deemed a work for hire, that you have the contractor assign all rights to the client. Ownership, limited license, and reservation of rights. These are typical clauses for, this was just my introductory list. I gotta go through this again. All right, so we've already talked about confidentiality, and I will give you some of the key things here. Usually it's in a separate agreement, but it doesn't have to be. It can be in a larger agreement on a different topic. The key elements are, what information is covered, what's excluded. It's important to identify what the permitted scope of use is. So if you're saying you can only use this for purposes of evaluating whether to enter into this larger agreement, then that would be the permitted scope, and you can't use it outside of that. It's important to say who's going to actually be covered by it, and to have the obligations survive the termination of the contract. Typically at termination of a non-disclosure agreement, there would either be any confidential information would either be returned or destroyed, and you're going to ask for some kind of verification of the destruction of that data. And you would also include some kinds of remedies for breach. Typically you'd have injunctive relief and could also have monetary damages. Okay, so when I mentioned work for hire, this is actually a the section of the Copyright Act that talks about what qualifies as a work made for hire. So if it's prepared by an employee within the scope of their employment, that's already automatically a work for hire. If it's commissioned, meaning by a contractor, then it has to fall into one of those categories. And timing is going to be important, because it's obviously going to be better to get the contractor to sign that prior to doing any work. Unfortunately, in the real world, that doesn't always happen because you find that clients who aren't aware of this have already hired somebody, that person's already done work or started work, maybe even completed the work, and they didn't have them sign the document. And as I mentioned, in addition to the work for hire language, it's good to have the assignment of rights in there as kind of a belts and suspenders to the contract. Okay, so now ownership, limited license, and reservation of rights. So if technology is actually being licensed, and sometimes it's not a license, it's just an right to access, like in a subscription sort of situation or hosted situation, you have to address what the scope of that is, what the duration of it is the other party allowed to use the marks or copy, the marks of the provider, and typically you have them preserve any copyright notices that are in, especially if you're giving them a physical copy of the software download of it. Reservation of rights is just making sure that you're only giving them that specific license and anything else is being reserved. And then this is just an example from Microsoft Service Agreement. I don't know if you can read that, it's kind of small, but it's basically just saying that this is being licensed, it's not being sold, and Microsoft is reserving all rights that are not expressly granted by them. And then they go a step further, actually, beyond just reserving the rights. They go a step further and they say, we're not giving you any right to do any of these things here. Another typical clause would be audit rights, particularly if it's a license with restrictions. So, for example, if it's a license that says, you can have X number of users, and then you're only paying for that many users. So you want to, the licensor is going to want to have some audit rights to make sure that those restrictions aren't being exceeded, that the licenses aren't being shared beyond the number of authorized users. And sometimes you can actually put a trigger in there as well. So you can say that, for this price you can have up to 5 users, but if you exceed that, then automatically the price is going to go up to this higher amount, and you can have that already set in the contract. Remedies could be there could be enhanced termination rights. So, for example, if the license is being exceeded, one of the remedies might be to allow for, like immediate termination, but you can also address it with injunctive relief and liquidated damages in the contract. And then limitation of liability. This is, of course, important in really every contract, but it's equally important in technology agreements. And it's very typical to see that indirect damages, indirect, special, consequential, whatever term that you want to use, are typically restricted. And then with respect to damages, there's usually a cap. It might be a dollar amount, or it might be a formula such as a certain month's worth of fees paid. Limitations of liability may not always be mutual, especially if you're dealing with a larger tech company. They'll typically have these protections for themselves, these caps and restrictions, but not necessarily for the licensee, although I'd say more often you'd see the restriction on special damages. That one might be more mutual than the cap on damages. And this is an example from Google's terms of service. And you'll notice that they start out by saying when permitted by law. That's one way to do it, because there are states that will say that these are not valid under certain circumstances. I know New York is one of the states that holds that if you're limiting liability, you can't do so if there was fraud, for example, or gross negligence. So when permitted by law, Google, their suppliers, their distributors will not be responsible for lost profits, revenues, or data financial losses or indirect, special, consequential, exemplary, or punitive damages. And then again, in the next paragraph, they're saying to the extent permitted by law, the total liability of Google, its suppliers, and distributors for any claims under these terms, including for implied warranties, is limited to the amount you paid us to use the services, or if we choose to supplying you the services again. And realize that this may be a situation where this was a free service. So effectively, if they're saying our liability is limited to the amount that you paid, well, if it's a free service, then essentially they're saying you're not going to get, not only you're not going to get any indirect or special damages, you're not going to get any direct damages either. So, even if you don't draft contracts and you're not practicing in this area, I know a lot of you are practicing in many different areas, it's still important, I think, to know this because these contracts do come up on a regular basis, whether it's for your own firm, whether it's for a client, and it's just important to be aware of the importance of some of these terms. And even, in your own personal life, when you're buying a phone or you're going to a site and you have to accept terms of service. Most people don't read them, but they are legally binding, and so and we all know that, right? Because if you remember from contracts, the fact that you didn't read the contract is not a defense, right? You're still bound by it, and that's true with all of these online terms as well. There are some exceptions, but those are kind of few and far between. There was actually a case 2 or 3 years ago, and it was one of the I think it was TransUnion credit reporting service. And they have an option, and I think all of these credit reporting services have this option where you can pay for a report. And so this individual had paid for I think it was $30 or $35 to get a report. And instead of having like a click-through, I agree, they had a box. And it was one of those boxes where you had to go in and actually scroll through the box. Like all you could see was a portion of the terms. And in that case, that one, when it went to court, because he did sue them to get his money back, and they wouldn't give him his money back. I think it might have been an arbitration clause as well. There was buried arbitration clause in that box. But he never saw it because he never scrolled through, and the court actually said, this is not going to be, we're not going to hold him to these terms because and I think the fact that it was TransUnion versus an individual factored in there too. So if it had been TransUnion versus some other large company, it may not have been the same result. But here you have this individual who's paying for a service, and then they try to enforce an arbitration clause that's buried inside a box that he really would have had to, I think, take some extraordinary efforts to look at. So other than a situation like that, these are the terms of service that are available online are generally going to be upheld. Does anybody have any questions? I know we've probably got a couple minutes.
Yeah.
Anyone? I want to give you your full hour, CLE hour.
I do have one. I've just been teaching about the click wrap situation, browse wrap. Of course, the students know all use this far more than I ever will. And one thing that always gets me is absolutely nobody reads anything. So how did this one particular, they admitted it to me, I don't read it. And I said, did you click on I agree? Yes. Okay. I understand it. But how did this particular person dealing with TransUnion get away with it?
Well, because of the fact that it wasn't it wasn't like the whole page had the terms on it. Within the page, there was a smaller box, and it had its own scrolling. Like he'd have to go specifically inside that box to get all the terms out of it. And I think the other factor was that the button did not clearly say, I agree to the terms. It was something like, click here to purchase your report.
Oh.
So it was a combination of the fact that they had this other separate little box and the fact that their button wasn't even clear that it was an agreement. So when you actually click I agree, you're giving your assent, whether you've read it or not. But in that instance, and really, you know, TransUnion is not a small company, right? But they did not, according to the court, they did not use the right terminology there on their button.
What was the issue in that case that brought that up to light? Like brought that to light in the first place? Why did he?
Because he was trying to get a refund on the report, and TransUnion said you have to go to arbitration. We have an arbitration clause in our terms, and then that's when, you know, I think he must have sued them is how it came up. If you didn't already get one, there's packets with just my card, my rack card, and then I also have this is a cord wrap, so you put your phone cord in there. And again, these are all kind of examples of my branding too. I do a lot of just little branding with, I like to give out sort of tech gadgets. I also, twice a month, send out an IT law alert. And if you would like to get on that, it's just a MailChimp kind of email that goes out. If you would like to get on the distribution list for that, if you're not already on it, just give me your card or shoot me an email, and I'll be happy to add you to the list. What we cover are either court decisions or legislation that's coming up. And I think the last one was the one I sent out this week was last week was the Security and Exchange, I think it was the Security and Exchange Commission. I'm forgetting which agency, but it was a federal agency that's put out or that there's a law that is pending, and it passed the House like with only 3 no votes. So it was a bipartisan bill to establish a kind of a bug bounty program for one of the agencies to allow ethical hacking and then to pay those ethical hackers for what they find. So that's just to give you an idea of what the type of topics that I cover in the alerts. Okay, thank you.
Well, folks, thank you so much for attending, everybody. Thank you very much for being here and sticking around. Don't forget to sign in for CLEs and the sign-in sheet. Please visit the table in the back for TPMB merch. We still have food outside and drinks, so please help yourselves. And yeah, thank you again for coming.
Thanks.